Well, hello and welcome to this Cornerstone Barristers webinar on local plan examinations. Thank you all very much for attending, especially, so I look out of the window, on such a sunny afternoon when those of you not in back-to-back Zoom or Microsoft Teams meetings might have been usefully engaged in unlimited open-air recreation or exercise. But hopefully we'll discuss some matters that will make your decisions to participate in the webinar instead worthwhile, or at least a fair trade for giving up an hour of your valuable time. Now, in a moment, I will introduce my fellow presenters, but first, just on housekeeping, I think due to the numbers of people that we've got involved, I think we've already got 191, gosh, it's changing by the second, 191 people, but due to the numbers of attendees, I think everybody is muted with the exception of the presenters. So questions and comments we'll deal with those using the Q&A function on the bottom of the Zoom bar. And we've already had, thank you very much, a large number of questions and comments from attendees, which we've tried to take on board when we've prepared our presentations. So the format for this session, which should last for an hour, is that we'll have 3 short presentations of about 10 minutes or so from each of us. And then we'll move on to the Q&A session. So can I say just a little bit about who you'll be hearing from this afternoon? First up, there will be a few words of general introduction from me to the afternoon, but then Wayne Beglan will be providing us with his update on the duty to cooperate, which is clearly a very hot topic at the moment, and you will have seen another addition in relation to South Buckinghamshire dropping through in your emails and news flashes either today or yesterday. And of course that's only an interim decision, but it clearly indicates the way things are going in South Bucks. Many of you will already know Wayne, who has a great deal of experience of local plan examinations. And actually, Rob, could you just, I think we've got a slide, I think police officers call it antecedents when a criminal is being sentenced for past crimes and misdemeanors. But what we've just got there is some antecedents which relate to us. But anyway, going back to Wayne, clearly considerable experience, including promoting plans for Waverley, Welwyn, Harlow, Luton, as well as pursuing objections elsewhere, including at Central Bedfordshire. Then you'll be hearing from Rob Williams on the hardy perennial of sustainability appraisal / SEA, which continues to catch people out. And Rob, again, I'm sure will be well known to many of you, and he has promoted plans in Guildford, assisting Wayne at Waverley, Tunbridge and Morling, and also assisting with me at the North Essex authorities, as well as promoting objections elsewhere, including, as I know to my cost, at Craven in North Yorkshire. Lastly, you'll be hearing from me, Michael Bedford, on some of the practical matters, including the COVID adjustments, and also a few other points that we've picked up from recent examinations. Now, as one of the attendees kindly pointed out in a query to Carolina, our events organizer, I have been involved for quite a while with the local plan world, and he recalls me participating in a local plan in Elmbridge in Surrey, actually back in the last century. I think it possibly was 1990, but it might have been 1989, but there we are. More recently, I have had the great joy of helping Forest Heath with both their single issue review and their site allocations local plan, which those of you who followed events in that part of the country will know was a very long gestation period. And I had perhaps slightly less joy trying to help Uttlesford cope with both a complete change of political control and an inspectorate team who took a slightly different view of the words pragmatic to many other participants in the local plan process. However, moving swiftly on, the theme of this afternoon's webinar is on how best to overcome the challenges of securing an adopted local plan, and hopefully one able to withstand the rigours of a Section 113 legal challenge. That theme has obviously heightened importance since, as we all know from recent experiences, outside of Essex as well as inside of Essex, inspectors are indeed prepared to see plans fail if they're not satisfied on key matters. And secondly, as we know, the government has reaffirmed its intention to require all areas to have plans in place by December 2023. Now that deadline, as you know, was announced in the March 2020 paper Planning for the Future, the precursor to the promised white paper, but it was reiterated by the Secretary of State in yesterday's planning update. Those of you who are, in a sense, Kremlin watchers and therefore sort of attach excessive importance to the precise wording might note that in the planning update, this deadline is referred to as an aspiration, which, you know, if you wanted to be benign, you could see that as a softening of what was a deadline into an aspiration, perhaps in recognition of practical reality. But if you don't want to be benign and you want to take the words at face value, the deadline is there, it's December 2023. And it certainly would be prudent for those of you engaged on preparing and producing plans to assume that the deadline is there until we're told that it's not. We certainly know that it has been applied in practice, specifically being referred to by the Secretary of State in the directions that he issued to South Oxfordshire, which we obviously all know about, but as set out in the letter to South Oxfordshire of the 3rd of March 2020, and requiring that the plan not only proceed, but it proceed with a view to the examination being completed and the plan being adopted by the end of 2020. Now, we don't have time this afternoon to explore why it is that there are more and more examples of plans falling down, and I'm sure you will all have your own ideas about that. Some might blame officers. This might be the development industry take. They might blame officers for having difficulty in standing up to their members. Some might blame the increasing complexity of the system with ever increasing demands from both policy and legal requirements. And some might blame the lack of adequate or sufficient resources to ensure both a robust evidence base and the personnel to deliver the plan through its preparation processes. And obviously there's going to be something in all of that in different parts of the country, but I'd say I'd just like to float the idea that there is one factor which, sort of certainly based on my experience, I think has got something of a role, which is that since, and obviously it stemmed initially from the 2012 NPPF, but it's reinforced by the 2019 NPPF, we see the shift in policy to requiring effectively, and I summarise the presumption, but requiring all objective needs to be met in full unless they can't be. And now that's obviously a very different approach to the previous approach of allowing a balance between constraints on the one hand and needs on the other, so that constraints would temper the extent to which needs could or should be met in a particular area. And I say it does seem to me that that change has increased very much the need to make hard choices by local authorities when they are plan making. And in many parts of the country, and in particular in many parts of the southeast and the east of England, where much of the development pressure exists, there are no easy choices left, no obvious, straightforward sites that can be just popped out and added and nobody's going to be terribly concerned. In many parts of the country, the easy choices have all gone. And so you are beginning to, as it were, metaphorically cut to the bone when you're making significant releases of land, particularly for housing, but also for other development needs. So with that context, if I can now turn to Wayne, and he can talk us through overcoming the first key hurdle, the duty to cooperate. Thank you, Wayne.
Well, Michael, thank you very much for that introduction. If we can move on to the first slide, one of the things that Michael was introducing was the idea of the race to 2023. One might think perhaps a slightly unusual race to take that long, but that's the deadline that the government is seeking to put in place for every authority in England to have its local plan adopted. And one of the hurdles that the local plan will need to get past is the duty to cooperate hurdle. That can be a particularly difficult hurdle because its binary nature means that it is a pass or fail test, and there is no discretion in the inspector, as the law presently states, to allow the inspector to correct any deficiencies in the duty to cooperate that are identified. And so therefore, a failure means going back essentially, more often than not, to square one and restarting the plan. And one of the difficulties with that is that by the time an authority is required to go back, the factual matrix making up the evidence base may well have changed. Authorities in neighbouring districts will have moved on within their planning processes. And so in addition to updating the evidence base, there may well be additional problems that arise in relation to taking additional steps so that the duty to cooperate can be fully complied with in the next round of submission documents. One of the difficulties that arises is the lack of any particularly helpful prescriptive guidance as to when the duty to cooperate is met or not met. But those of you who have looked through the 2019 updates to the PPG will see that there is a deal more there that is specific in relation to how local authorities can guard against failures in the duty to cooperate and try and ensure that they have done enough to meet the requirements. One of the reasons it's very important for authorities to ensure that they have done enough is because if they're subject to an adverse finding from inspectors, challenging that in the courts tends to be a very difficult process because it's quite clear that the inspector is exercising planning judgment, and so upsetting any judgment of that kind, as experienced officers will know, is very difficult within the court process. So moving on to the next slide and just saying a little more about the binary nature of the process, because at the moment there's no ability in those promoting emission sites to directly have their sites considered through the local plan examination process, then quite often they look for indirect ways of attacking the plan process, and duty to cooperate is one of those. And making criticisms of the sustainability appraisal is another, which it will be Rob's domain a little later on. So it's important to bear in mind that there will be individuals who will potentially want to come and attack reasonably aggressively the approach that the plan making authority has taken to the duty to cooperate. And so one of the things that we do is recap very briefly on the legislation, and the slide shows where it's found, and we're familiar with the terms of the duty to cooperate. It's the mandatory duty to cooperate in maximising effectiveness of the activities undertaken in the plan making process. So that's the key to the duty. And of course, we see in inspectors' reports that are produced always the references to whether or not that engagement has been constructive, active and ongoing. And the reason for that is that is the formulation taken directly from the the primary legislation itself. And in relation to the prescribed bodies, there is also the requirement to have regard to the activities of those prescribed bodies. So in the next slide, what I've done is set out, just as a reminder for those who need to refresh themselves, the main prescribed bodies under the regulations and the way that the LPA needs to react both to those authorities and to county councils, for example, in relation to highways and education provision, but also as a matter of guidance. This is guidance that's in the MPPF and the PPG. They also need to take into account the position that's taken by the local enterprise partnerships and the local nature partnerships, because they, by their nature, cover a broader area than the individual local authority and are looking at things on a strategic level. So it's always important to take those into account as well. And to do all of this, the guidance shows at the earliest stages of the plan making process. So when scoping is being undertaken, when the initial parts of the evidence base are being put together. So as we move on to the next slide, an important limitation on the extent of the duty to cooperate. And so if people are objecting to a plan making process, they need to be able to fix on what are strategic matters, and the local authority, the plan making authority, only has to defend itself against attacks to what relate to strategic matters. And what is a strategic matter is defined in the legislation itself, and we put the definition there, but I've also put in the other box some key examples of where in inspectors' decisions certain issues reoccur time and again in relation to securing compliance with the duty to cooperate. And for those who have seen a number of decision letters, it will be a familiar list, but it's issues like the spatial strategy, where development's going to be located, how it's going to be distributed. All of those things will quite often tend to raise the prospect of there being significant impact on neighbours depending on what's proposed by way of those developments, housing and employment, and the need to meet in full across the relevant areas. Those requirements are something that often come to the fore. The issue of green belt across boundaries can be a problematic one, because most green belt studies only take into account the actual area of the administrative authority concerned, and that can be a perfectly sensible approach, so long as the analysis is not blind, as it were, to what is happening nearby, just outside of the administrative boundaries. And there's increasing view about the utility of having green belt analyses that go across a number of relevant authorities, so that a more holistic approach can be taken. And the other obvious matter, key strategic matters, relates to infrastructure, and that's something that has received more explicit guidance in the 2019 versions of both the MPPF and the PPG, but there's an obvious need there to consider adequate provision for things like improvements to the road network and for the appropriate location of schools, in particular secondary schools, which tend to have far greater land take. And so one of the questions that we ask, being where we are now with the later version of the MPPF, MPPG, is what a difference 7 years makes, or indeed does 7 years make a difference, as it turns out. And 2012 MPPF together with the 2014 PPG still applies to those plans that were submitted before the transitional date in early 2019, and the new guidance applies to those later plans. So although the old, as it were, PPG guidance now says it's archived, it's necessary to have access to that if you have to deal with plans that are operating under the transitional provisions. Now, I've set out within the slides where in the MPPF itself, the guidance on duty to cooperate, such as it is, can be found within that document itself. And one of the interesting things about the change in the MPPF is simply the structure obvious, and the way that plan making has now been brought to the fore numerically in the paragraphs of the NPPF, featuring at a much earlier stage than it did in 2012. When we look at the PPG, in fact, the substance of the guidance in terms of what needs to be done to secure compliance with the duties to cooperate is much the same, and that may be unsurprising, bearing in mind that the primary legislation hasn't changed. But what has changed is the explicitness with which the use of statements of common ground to satisfy the duty to cooperate has been changed, and that is now very clear in the guidance to which we've made reference on the slide. And both the new NPPF and the PPG identify statements of common ground as being the means to demonstrate duty to cooperate compliance. So it's obvious that they are meant to be the primary instrument for that purpose, and indeed even in transitional plans they're being increasingly employed to that aim. But it's worth bearing in mind that in ID 61031 that we've referred to, that preserves the ability of plan-making authorities to rely on other sources of evidence as well to demonstrate compliance with the duty to cooperate. So again, as we move on through the slides, one of the things I wanted to do without taking time on the detail of the individual cases is just to remind everyone of 5 of the main authorities that deal with the duty to cooperate, and I've tried to do it by reference to simple mnemonics so that hopefully these authorities will stick in your mind, and then when the issue comes up you'll know instantly, that's Zurich, that's the one I should be turning to for this question. So Zurich contains an interesting discussion of strategic matters in the context of housing and what does and does not constitute a strategic matter. And it also looks at the nature of the obligation on a plan-making authority to consider, and it's no more exacting test than that, to consider the idea of joint approaches that might be made with neighbouring authorities through the plan-making process. The Selby case is the well-known case where it was established that plan making stops at the point of submission. So an authority can't rely on steps that are taken after the date of submission in order to demonstrate that there is compliance with the duties to cooperate. But it's worth bearing in mind that, of course, evidence can be usefully submitted to examinations after that point in time to demonstrate first of all, what has gone before and how successful that has been, but also to demonstrate successes that do actually occur during the period of examination, because they will tend to show how successful the groundwork was for what was being done before the date of submission. So all of those things can be helpful. Central Beds is a case that gives some pretty clear guidance about the fact that a finding on the duty to cooperate is a matter for the inspector to consider, as I indicated earlier. Barker Mill Estates is an interesting case, bearing in mind what's recently happened at Sevenoaks, because it's a case where the inspector was sufficiently persuaded that although there was an unmet housing need that potentially could have been exported, the local authority had adequately investigated the position in order to satisfy itself that it already knew what the answer would be if it asked its neighbours whether or not they were in a position to make a contribution. And it told the inspector that it knew the answer was going to be no. And the inspector said in terms that he was impressed overall by the way that the authority had approached the duty to cooperate process, and was impressed by the level of knowledge that they had about those issues. And so in those particular circumstances, he said he was satisfied that the duty had been met, and that was upheld by the High Court. The St Albans case, again quite well known, was the suggestion that St Albans have found themselves at an impasse in relation to whether or not they could identify the same housing market area that 4 of their neighbouring authorities, who had all clubbed together and produced a joint schma. And in those circumstances, the court said, the inspector said, well, it's not good enough to say without some far more rigorous consideration of the facts that you've just reached an impasse. You needed to have done more in relation to considering the housing market area. Now, it's often said, as we move on to the next slide, that the duty to cooperate is not a duty to agree, and of course that's right. We know from the graphic there that it's not unusual for 2 people, 2 authorities, to look at the same thing and take different things from it, perhaps see it quite differently. But in those cases where there is disagreement, then what it is important to do is to demonstrate the level of engagement that's been carried on in order to get the parties to where they are, to focus back on those initial tests of it being constructive, active, and having been on an ongoing basis. And a critical thing as far as examination inspectors are concerned, time and time again, is to demonstrate that the decision makers, the individuals who potentially can really shape how a local plan emerges, are there at meetings and are consulted about meetings from the very earliest points of plan making. If you ensure that as an option, if you're a plan making authority, then you will put yourselves in a very sound position to demonstrate compliance with the duty. And even where there is disagreement, there is also added value in identifying the parameters of what has been agreed and therefore what hasn't been agreed, because that will allow you still to take those issues forward in influencing the shape of the plan and how it should be progressed. And inspectors will see that there is an element of cooperation that's borne some fruit there. So if we move across to the next slide, we can note that because of the binary nature of the duty and the prospect of failure, it is a strong motivator for authorities to agree between themselves. And when that happens, and this advice may to a certain extent seem trite, but it's reflected in the guidance. First of all, record that. Make sure it's as specific and detailed as the circumstances allow. So if you're dealing with a case of housing, the numbers for which provision is being made should be identified, so should the approximate location. It may be useful to identify type, mix, and so on. And indeed, the issues relating to infrastructure that affect that kind of provision. Plan making authorities should try and avoid agreements which look anodyne, agreements which look like they're in fact agreements to agree later, because inspectors will quite often take that as being a potential deferral of obligations, which is something they're quite astute to look for within the examination process. So that is something to be avoided. And again, if we can move on through the slides, just some general issues that arise from some of the cases in the application of the duty. There is no what I've called mirror principle. Well, what do I mean by that? It's sometimes suggested that where you have, for example, authorities with a common housing market area, if one of those authorities fails the duty to cooperate, that must necessarily mean that the other authorities within that HMA will also fail when their examinations come forward. And that can be quite an acute issue when you've got examinations that are proceeding almost in parallel. But in my view, that's not correct. And one easy way to test that is to consider the historical relationship in the planning process between central beds and Luton, which I've referred to there. And to cut what became quite a long story really back to its bare bones, in its previous iteration of local planning, central beds were unsuccessful due to a failure to meet the duty to cooperate. And that was largely due to a failure to consider sufficiently their ability to deal with Luton's exported housing need, which was of a very large quantity. But that didn't prevent Luton from not that far in the future then demonstrating that in fact they had complied with the duty to cooperate by taking adequate steps to try and address those needs, even though they couldn't be fully met. And indeed, as central beds go through their examination this time around, the appearance is that the inspectors may be satisfied that they've met the duty to cooperate. And the reason why there is no mirror principle is set out on the slide. It's because it's a matter for the individual inspectors to judge against the background as a whole and against the steps that an authority has taken as a whole, which will not relate simply to the issue of housing. So that's the mirror principle. Moving on to the next slide, we just take some other headlines from recent reports. And again, I've given 5 examples just of ways that the duty to cooperate can be met and sometimes where failures arise. An important point to note is that it need not be a failure of the duty to cooperate for authorities to actually have proceeded on a basis that an inspector ultimately considers is not correct. So they may have agreed not to make provision for certain unmet needs. The inspector may disagree and say, well, you need to have done that, but still treat it as a matter of soundness, and that's Waverley and Guildford. St Albans is the next one, which we've dealt with in relation to its most important point. Sevenoaks, a number of you will be familiar with relatively recent correspondence and now the prospect of judicial review challenge in relation to Sevenoaks' failure to formally ask its neighbours within the housing market area for assistance on having changed their approach to housing so that they had a significant level of unmet need, which then needed to be met potentially one way or another. And an interesting, very recent example, Michael referred to Chiltern and South Bucks, which demonstrates the point that it's actually not necessarily sufficient for a plan-making authority to say what might be thought to be quite an attractive submission. Well, we can't help an adjacent authority because we can't even meet our own need. And that may be a sufficient answer, but not necessarily. It will depend on issues like whether or not there's been an adequate consideration of whether or not greenbelt land might be released in order to assist your neighbour. And in that case, it was the very substantial unmet need that was arising in Slough of many thousands of units that required at least more consideration as far as the inspectors were concerned. And then lastly, returning to Luton and Central Beds, the fact that the authorities are not actually fully meeting the needs within the HMA is not necessarily fatal in terms of the duty to cooperate. See the approach that the inspector took there. And so moving on to the last few slides, inspectors do pay particular attention to the outcomes within the plan making process, and there's an obvious reason for that. But because we know that inspectors will focus on outcomes, we have to ask ourselves, what lens are they looking through? And the main lens they're looking through, because they're testing the soundness of plan policies, is to consider those plan policies and how the duty to cooperate, starting from the earliest stages, has effectively helped to shape those policies. And so anything that can be demonstrated through the audit trail that the plan making authority has that shows that the actual policies of the plan have been influenced will be particularly persuasive in terms of presenting successful outcomes. And that must be so in particular in relation to issues like housing, which is such a current priority for the government within the plan making process. So we've got one more slide on outcomes, and it's just to emphasize, and all of these potential outcomes being relevant to the duty to cooperate are expressly endorsed in the guidance in the PPG. So the fact that you can identify what's not agreed, for example, and how it might be addressed through the plan making process is part of complying with the duty to cooperate, or can be. Identifying common parameters for studies, what's going to be studied, the basis upon which it's going to be studied, considering the outcomes of the study in relation to greenbelt, urban capacity, all of those kinds of things that can relate to the ability of the plan to make adequate provision for housing, and how the evidence base within the emerging local plan process is to be treated. Agreement in relation to any or all of those things can be capable of going towards the duty to cooperate. And so we move finally to consider the importance of audit. And of course, inspectors are always examining compliance with the duty to cooperate by reference to the available evidence before them. And what that means is the keeping of detailed records is absolutely critical, and in particular showing, as I indicated earlier, where the decision makers are involved and the influence that they had in relation to that. So whilst, for example, providing chronologies of various meetings that relate to the duty to cooperate can be useful, that's not necessarily going to be sufficient. And the use of primary materials like the actual emails that have been produced moving between duty to cooperate partners can be very important to demonstrating compliance with the duty. And so finally, just some thoughts for the future. And it is clearly unfortunate that failures relating to the duty to cooperate are bringing a number of plan processes to a halt, especially bearing in mind the government's clear desire to have plans adopted in the relatively near future. And so there are future options for consideration, some of which have been suggested by the attendees today, and a very useful list sort of emerges from some of the points that have been put in. But it's possible the primary legislation might be amended in order to give the inspectors at least some residual power to deal with deficiencies in the duty to cooperate, and that would certainly allow examinations to be taken forward more readily, rather than having to go back to stage one with the updates to the evidence base and so on that I have described. It's possible that some more prescriptive guidance might be a further help to the plan-making authorities, or either that or a return to more exploratory meetings where at a much earlier stage there is consideration by the inspector as to whether enough has been done on the duty to cooperate, at a stage where it could still potentially be remedied without having to rework the evidence base, which is one of the key reasons for delay within resubmission in the plan-making process. So those are our thoughts in relation to the duty to cooperate, and how plan-making authorities and those who wish to make objections to plans might approach some of the current and controversial issues that are arising.
Thank you very much, Wayne. Thanks. Right, okay, well, let's move swiftly on. So Rob, please, if you can tell us about sustainability appraisal.
Thank you, Michael, and good afternoon, everyone. Before we get to sustainability appraisals, I want to address something that was in the news headlines today, nothing to do with local plans. It's that New Zealand has allowed its hairdressers to reopen as of today, and there have been reports of people queuing overnight for haircuts. Now, the news is obviously of more relevance to me than Wayne, because much to the embarrassment of my wife, I'm currently sporting what can only be described as a lockdown perm, for which I can only apologise. Anyway, enough about my unsustainable appearance. We're here to talk about sustainability appraisals, and particularly the role of sustainability appraisals at a local plan examination. And at a local plan examination, an inspector focuses on an essay for two primary reasons. Firstly, to assess whether the essay is legally adequate, and secondly, as part of their determination of whether the plan is sound. Now, I'm sure a large number of you have been to many number of examinations, and sometimes the essay is front and centre of the examination. It comes up again and again throughout of the issues discussed, and sometimes it's discussed on the afternoon of day one, immediately after duty to cooperate, and then hardly referred to again. And to some extent, that depends on the plan, and the some authorities use the sustainability appraisal as a key plank of their evidence base. Others rely on other parts of the evidence base more heavily, like topic papers and like. But it also depends on inspector to inspector. Some inspectors treat the essay as a critical piece of evidence, central to the evaluation of soundness. Others more as a cross-check or a sense check as to how the plan has progressed in its soundness. But all inspectors will consider the legal adequacy of the sustainability appraisal, and inspectors are under a duty to determine whether the plan satisfies certain legal requirements relating to the preparation of DPDs. Now, in my view, Section 25A is not well drafted. The scope of inspectors' duties in this regard is not entirely clear, but it is invariably the case that inspectors will consider whether the sustainability appraisal is legally adequate, and in particular, whether the requirements of the SCA regulations and directive are met. And it's not unusual, as you all know, for detailed legal arguments to be flying around, opinions from leading silks coming left, right and centre on this topic. In terms of soundness, as a matter of law, it has been held for a long time and reiterated recently that the essay process is entirely procedural in nature, in contrast to appropriate assessments. For instance, under the Habitats Directive, an essay informs decision-making rather than dictating it. And that was reiterated in the High Court level of the Spurrier case, which related to the Heathrow challenge. But in practice, the essay often forms a key part of the evidence base against which the soundness of the plan is tested. It's obviously more than merely procedural in that regard. It has often direct implications for questions of soundness. Now, that is most obviously the case when an inspector is assessing whether a plan is justified. Obviously, if there's a robust essay which concludes that the plan is the most sustainable, or now in the 2019 NPF, sustainable approach when considered against the alternative, it goes a long way to ensuring the test of soundness is met. And the PPG in the text I've given there expressly recognises the potential role the SA can play in demonstrating soundness. Another example of the relevance of the sustainability appraisal in meeting the test of soundness can be in relation to green belts. We know that one limb of the soundness test is consistency with national policy, and we know that green belt boundaries can only be amended if there are exceptional circumstances for doing so. So where a robust SA has tested alternatives for delivering development outside of the green belt and found those alternatives to be less sustainable, that can form a key plank of any exceptionality case. And I've put up there a couple of examples, recent examples, of where inspectors have considered the SA and directly considered how the SA findings impact on the findings of soundness. In Bedford, to take it very shortly, the inspector was impressed with the sustainability appraisal and it found it was robust, and in part based his judgments on soundness on the basis of that. Contrast that with the Hart local plan, which was adopted only a few days ago. That plan, when it submitted, originally had a policy in it proposing a new settlement, which would come forward under a daughter DPD towards the end of the plan period. And whilst it would meet some of the housing needs within the plan period, it was primarily a way of meeting long-term needs in the area. Now, the pre-submission sustainability appraisal in that case didn't test any alternatives for meeting long-term needs. The local authority sought to rectify that post-submission, prepared a post-submission essay, and did consider alternatives. But the inspector closely considered that and came to the conclusion that that post-submission essay didn't allow for suitably robust comparison of alternatives, and on that basis couldn't find that the policy was sound. He recommended in the main mods the removal of the policy, and indeed the policy was removed from the adopted local plan. Turning then briefly to some of the core principles, and they are only some of the core principles. I'm not suggesting by any means this is an exhaustive list of principles that apply, and they're derived predominantly either from the regulations and the case law on the regulations and directive. I've split this up into two sections, the plan and the reasonable alternatives. And although some of the principles apply to both. Starting with the plan, the first two principles I've set out there on the left, they are self-explanatory, I hope, and don't require any further explanation. The third one is an important caveat, and it's often overlooked. The information required by Schedule 2 or Annex 1 to the directive is only required so far as it may be reasonably required, taking account of the four matters that I've set out there. And therefore, that allows for a significant amount of evaluative judgment as to how much information is required and whether the information is required in this particular essay. So one key dispute, which I'm sure you're all aware of at the moment, is whether local plans or essays supporting local plans are required to undertake a heritage impact assessment or something similar along the lines of a heritage impact assessment in order to be adequate. Now, obviously, I'm
not sure what's happened to Rob's connection there. We'll just give him sort of like 5 seconds or so to sort it out. And we may have to... Rob, do you want to...
Can you hear me now, Michael?
Yeah, we can hear you now. Okay. Carry on.
I'm sorry about that. Sorry about that, everyone. Either my wife or my daughter was using the internet to a large degree. I'm not sure where I got where you heard me up to, but I'll carry on with the HIA example that I had. I'm sorry, and I think you probably... I think that's all appropriate now, and you can see the slides on my screen. The HIA example, yes, as I was saying, the one key dispute is whether an HIA is required for SA purposes. And that depends, in my view, at least in part, on the content of the plan, the stage of the plan in the decision-making process, and whether it would be more appropriately addressed at a different level. So, for instance, if you have a plan and there is going to be a DPD following it, either master plan DPD or a Part 2 DPD, it may well be arguable, at least, that it's appropriate to defer that type of consideration to another level of the SA process. There's no requirement for full information, that's well settled, and reasons for preferred options are required. That last one on the plan is an important one. It's sometimes overlooked, not least because it's not set out expressly in the directive or the regulations. In a case of Heard some time ago, Mr. Justice Newsley held that adopting a teleological approach, whatever that may mean, means that reasons for preferred options are required. Turning to reasonable alternatives, first of all, the first one is key. Reasonable alternatives are reasonable alternatives which take account of the objectives of the plan. They're not alternative plans. And that's something that's often overlooked by inspectors, by objectors, and sometimes by inspectors too. Reasonable alternatives does not include all possible alternatives, and in reality, we all know that the SA can't test all possible reasonable alternatives. What an inspector looks for is that there has been a range of alternatives which have been tested, which capture the range of reasonable alternatives. Thirdly, reasons must be given for selecting the alternatives that are dealt with, and the corollary of that is reasons must be given for discarding options that are not reasonable, albeit reasons don't need to be given for obvious non-starters. Finally, and an issue which often causes some problems, is that reasonable alternatives are required to be assessed in a comparable manner. Now, again, that's not something that's set out expressly in the regulations or directive, but it is within the EU guidance, and case law has indicated that reading the directive as a whole, it is a requirement. And that can cause some difficulties. If I go back to the HIA example, if you are required to undertake an HIA for allocations in a plan, it follows that you're therefore required to undertake an HIA or something similar for all reasonable alternatives. Turning then to whose judgment is it anyway, and you'll be glad to hear I'm not going to try my hand at improvised comedy, but the question is raised, ultimately, who is responsible for many of the planning judgments in the SA? And we know it's not the courts. Legal challenges to adoptions of local plan based on allegations of inadequate SAs face a high bar, and the Heathrow litigation has just reiterated that. But of course, courts exercise a supervisory jurisdiction. It's a central precept of planning law that courts are not concerned with planning merits. Inspectors are not in the same position as courts. Inspectors, even those examining plans, do make planning judgments, although they do through the prism of soundness. But in practice, inspectors regularly defer to judgments made by local planning authorities, so long as those judgments are rational, they're not inconsistent, and they're supported by evidence. So we will often have heard inspectors ask, do the errors that you allege are in the SA disclose a fundamental problem with the methodology? Or is the issue you raise a showstopper? Or do the criticisms render the plan or policy unsound? As a whole, inspectors are not interested in resolving disagreements about planning judgments which have been made in the SA. And I could have chosen a whole host of examples of this in recent local plans, but I thought this was a very good one from the recent Harrogate Local Plan Inspector's report, where he says disagreements about the SA are completely unsurprising. Indeed, they're inevitable given the scope for planning judgment. What he looked at was whether the conclusions reached were reasonable ones, and whether omissions, errors, or inconsistencies that do exist result in the SA being fundamentally or even substantially flawed. And although you won't find that in as guidance, anyway, at least as far as I'm aware, as a guide stick. That is what local plan inspectors often apply. Is there some fundamental error? Finally, to what extent can defects in the SA be cured? Now, it's settled law that defects in the sustainability appraisal can, in principle, be cured post-submission. Indeed, they can be cured up to the date of adoption. And I've seen a number of legal arguments advanced, however, that there's a limit on the new adstral or the cogent principle, that SAs can't be cured at a very late stage if there are fundamental defects, because that would be in tension with the principle that consultation on the SAs have to be sufficiently early in order to influence the final form of the plan. And that's a principle that's been reiterated, for example, in the Seaport investment case. In my view, whether or not there is a legal limitation on the new adstral principle, there is undoubtedly a practicable one. The later in the process one is trying to cure defects, the more significant the defects are, the more difficult it would be to persuade an examiner and ultimately a court that the flaws have been overcome, that the SA is objective, and that the conclusions of the SA have been taken into account with an open mind. And in my experience, inspectors tend to, or at least they should do, pay close regard to post-submission SAs, and the Hart local plan, which we referred to earlier, is a good example of that. So therefore, I end on this warning, particularly to local planning authorities: do not assume that the no adstral case is a get out of jail free card. Don't assume that you can fix issues with the SA later in the day. If there is an issue, if something has been overlooked, it should be addressed and rectified sooner rather than later. And with that warning, I hand over to Michael Bedford.
Thank you, Rob. Thank you very much. If we can just get the first slide up, please, Rob. Thank you. First bullet point is, I think, first bullet point, the most important one. There's no point chasing the elusive. We all need to be pragmatic. And that, in my view, is a message that should be shared by the inspectorate as well as by plan makers. I don't say anything about DTC or SA because that's now been covered. Obviously, just mention HRA. Obviously, you're all well aware that HRA, unlike the SA requirements, HRA is an absolute requirement in terms of the way that the habitat regulations work. It's not concerned simply with process, it's concerned with outcome. Next point, you, the plan making authority, have to consider the plan is sound at submission in order to you to persuade yourselves that it's ready for independent examination. That's the section 20 subsection 2 duty. You also need to make sure that you can get the inspector to a place that he or she thinks that there are main mods that will make the unsound plan sound. Otherwise, what you've been engaged in is a waste of time and money for all concerned, public and private sector participants. Next slide, please. These are just some points that it seemed to me that you should consider before you get to examination. The first one, choose a generous plan period. I think it's worth stressing, just because, as you know, para 22 of the 2019 MPPF requires a plan period for a plan with strategic policies to have a minimum 15 years from adoption, and it's from adoption. And we all know what happens. You start preparing a plan, you build your project plan, but then sooner or later things slow down. And then the question is, how are you going to still show 15 years at the point of adoption? So if you build in a more than 15-year period in your planning to start with, then you will be giving yourself a degree of comfort on that. Obviously, I think, again, the presentations already have made the point: ask and resolve the difficult questions early on. Make sure you've got a budget which not only allows you to produce your evidence base, but also to test it robustly. In other words, your evidence base shouldn't be just a tick box exercise. Have we got this study? Have we got that study? You need to critically appraise it and ask yourselves, where are the problems in this work, before objectors ask those questions. Be proactive, not just reactive on site choices. Don't just rely on your call for sites. You are the planning authority, you know your area. If there are areas of land which have got obvious sustainability benefits if they came forward, why are you not encouraging people to bring those sites forward? So I say be proactive in that. Be realistic in what can be delivered by both public and private sectors. It's always nice to think about that. Well, wouldn't it be nice if we had these wonderful types of development with all things, all singing and dancing provided, and that would no doubt be very palatable to local people who might be otherwise averse to the development. But if it's not deliverable, it's not deliverable. Keep it simple. What, where, when and how. That used to be in the PIN's guidance. It's a useful way of checking, are you actually focusing on the real things? And building resilience. Accept not everything you think will happen, and build in comfort margins. If you allocate more than you need, you might at least get what you do need. Next slide. These are just practical tips. Experienced programme officers are worth their weight in gold. With your evidence base, which will be voluminous, you need to know it, and you need to know how to signpost it in your submissions and representations. You need to ensure that you've given your officers delegated authority to suggest changes. You need a core team, including, I have to say these days, understudies, i.e. COVID, which will be with us for certainly a reasonable period of time. You can't afford to have key parts of your team taken out during the course of the process. You need to book your consultants, and MIQs, they need to be focused. Last one, you need to get the inspector to trust you, so therefore you need your responses to accord with those points. Next slide. So this is where we're in a sense, more uncharted waters in terms of the adjustments. You will have picked up on the update yesterday. It's clear that the government is very strong on wanting to encourage digital, as it's called, or virtual working, including for plan making. We know that PINS is still reflecting on how best to do that. There is, as we know, the 2 examinations to trial in June, others soon to follow. And we know that they've chosen a very easy one to start with. And I think there was somebody from South Oxfordshire booked in, so I'm not being rude, but certainly there are some challenges with South Oxfordshire. So clearly PINS wants to trial a difficult one as well as possibly a slightly easier one. Next slide. Yeah. This, just in terms of what I think, those of you who've had experience of DCOs will know that DCOs work on a hybrid basis. And I think we're going to see more of that migrating into the development plans work, with a lot more focus on written questions on specific matters rather than just the general open-ended MIQs. And I think we're going to see focused digital or virtual hearings on key matters. It's important also to note that the right to be heard isn't open to everybody. It's only open to the people who made submissions at the Reg 19 stage, and it relates to their reps at that stage. Others attend merely as observers, and that can perfectly well happen, it seems to me, through virtual means. People already are used to turning up at an examination and members of the public being put in an overspill room where they watch on a screen what's going on in the big room. There's no difference between that, in my view, and it happening slightly more remotely. And you will have all picked up that PINS is in favour of the use of Microsoft Teams. The last bullet point, I'm just making the point that, as you will know from sitting through examinations, when the inspector goes around the room, it's not cross-examination, it's not really a dialogue. What you need to be able to do is to make your points, and you make your points effectively, and you can do that in a virtual format just as well as you can in a live format. Next slide. Now, this is something that's been raised in a lot of the questions that we've had, and obviously, you know, we are not economic gurus, we are not planning policy makers. We don't have access to any more information really than anybody else, but it's quite obvious. COVID has altered the economy big time. We heard from the Chancellor yesterday and the Governor that we're in for what is going to be a serious recession, certainly in the short term. It seems to me that what is likely to happen is that for those examinations which are already underway, it should be possible to get by on the basis that, yes, we've got the existing evidence base. It's not realistic to, as it were, reinvent the wheel because of changes of circumstance. And I think inspectors would be receptive if they think that there have been those significant changes of circumstance to various assumptions which underpin the plan, to fall back on the promise of an early review rather than effectively a halt to the examination, going and getting fresh evidence and effectively starting with what could be a radically different strategy. However, I don't think that's going to wash with those plans which are still in preparation and have not yet been submitted. It does seem to me there that PINS will be expecting the evidence base to have been reviewed to make sure that it is actually reflective of the real world and the real world that we're now in. And so that does mean looking afresh at things like viability appraisals, looking at optimistic things about modal shift, and particularly the use of public transport, looking at employment land needs, particularly for those with city centres or large amounts of office floor space, and looking in particular in the housing context at delivery rates and are they realistic, certainly in the short term, and what does that mean in terms of both the 5-year supply, but then more in terms of the overall delivery of the housing that is required. Again, a number of questions have been raised asking about the standard method. And it seems to me that the guidance is very clear, and until such time as the guidance is changed, doesn't seem to me that inspectors will buy that COVID provides you with exceptional circumstances to justify you departing from the standard method. Next slide. I think we can take these points very much, they're in the slides. They are sort of interesting little asides in the world of plan making, but I think in terms of the timescale, it's probably more useful if we move to the questions and answers. So I think, Rob, you've been looking at some of the questions, and I don't know whether we want to identify questions that are then going to come to the fore that we might want to pick up collectively between the three of us. So perhaps, Rob, if you and Wayne can unmute yourselves, and we can see if we can pick some things up.
Well, I'm happy to start with one we got through, and then I think Wayne's been looking at the ones that have come in today. One question that came through a couple of days ago was about the impact of climate change in relation to local plans. And I thought that was relevant, not least because of the recent Court of Appeal decision on the Heathrow case. And just to recap that, in that case, the Court of Appeal ruled that the airport's national policy statement, the Secretary's policy on airports and its conclusions in relation to Heathrow as third runway were unlawful on climate change grounds, on the basis that the Secretary of State, when formulating that policy, had failed to take account of the Paris Agreement, which had been ratified some time ago by the government, and which the government had indicated in that House of Commons was part of its policy. And they found that there was a breach of the Planning Act, which required the national policy statements to explain how they take an account of government policy on climate change. And the Court of Appeal held that the Paris Agreement, by the time that the ANPS was being produced, was government policy. And they also said, quite apart from that, it was a failure to have regard to material consideration. Now, that's being appealed to the Supreme Court, and the Supreme Court, I think last week, gave permission on those grounds. So that's not necessarily the end of the matter in relation to it. But I suspect there will be arguments raised in relation to to what extent that translates over to local plans. particularly in light of the duty under Section 19 of the 2004 Act, which requires local planning authorities, as many of you will know, to include policies in their plan designed to secure contribution to the mitigation of climate change. And I suspect that there will be some arguments raised about whether the Court of Appeal's conclusions that the Paris Agreement is government policy and the failure to take into account was a failure to take into consideration translates across to local plans.
Thank you, Rob. Then Wayne.
In relation to the questions that we've been asked today, it struck me that 3 of the questions in particular were good ones to spend some time on today. 2 of them, perhaps unsurprisingly, reflecting a theme that came through in the earlier questions, relate to the COVID pandemic. But the first relates to whether or not we as the panel think that it's potentially feasible to produce joint strategic plans within the current local plan regulations. And as the question asks, without huge challenges in terms of proportionate evidence, consultation, and the duty to cooperate. And certainly my own take in response to that is that there is a need in the plan making process going forward for inspectors to adopt an increased level of pragmatism in how they approach the proportionality of evidence that's being supplied to support the plan making process, and how that evidence is assessed, and the proportionality and detail of material that objectors put in order to challenge conclusions have been reached in relation to the duty to cooperate, and indeed spatial strategy and other areas like that. It seems to me that there is an argument which may be furthered by the need to conduct local plan examinations virtually, which it seems we are probably going to have to do if we're going to get close to the government's target, for there to be a more streamlined approach in that respect. And I can understand the reservations of those who are currently thinking about embarking upon joint strategic plans about those concerns, but perhaps part of the hope can be that as we go forward through this new phase, there may be a recognition that in fact there is a greater imperative to simply get plans which, as Michael indicated, are never going to be perfect plans, on the books as it were, so that increasing levels of provision can be made, together with the infrastructure that is identified in so many plans as being particularly important.
Thank you, Wayne. There was one point which certainly has been raised by more than one in the questions, which was a COVID-related issue for people still at the plan preparation stage, which I think I tried to pick up in some offline exchanges. It's the problems of the 2012 regulations, because elements of them require certain documents to be made available, and Regulation 35 defines what made available means, and that includes physically being available at local authority offices for inspection during working hours. And for many local authorities, that's not practically deliverable at the moment. Some of the regulations only require compliance with that obligation as soon as reasonably practicable after a particular event. Particularly that applies at adoption. It also applies when a plan is submitted to the Secretary of State. That's regulations 26 and 22. And obviously, as soon as reasonably practical means what it says. If it's not reasonably practical to do something because of regulatory interference through the public health COVID restrictions, then it's not reasonably practical to do it, and you have to do it as soon as it becomes reasonably practical. So that particular element isn't a problem, but the killer, in my view, is in Regulation 19, which is what happens before you submit your plan for independent examination, because Reg 19 is expressed in simply black and white terms. It says you must, before you submit your plan for independent examination, you must have placed the documents available for inspection, which has to then accord with Regulation 35. So I don't see how you can get over your Regulation 19 requirements without having complied with the inspection requirements. And the only way round that problem, because there's no so far as reasonably practical let out for that one, is to amend the regulations. Now, we know that the government has amended the TCPA regulations in relation to planning applications and EIA applications, and they did that yesterday. They've spent time telling us why we don't need particularly to do too much to our statements of community involvement, other than read them and possibly amend them, but we can amend them without consultation. But what they haven't grappled with is the problem of Reg 19, and in my view, they certainly need to. So that's something which I think is a real problem, and perhaps those of you with connections with the Planning Officers Society and so on might like to make some fairly strong representations both to PINS and to MHCLG to get them to grapple with that problem. Any other questions, Wayne, that you wanted to pick up on?
Yes, well, one that was related to COVID-19 was about how committees, planning committees and local authority decision making might work in relation to emerging local plans. And the question was, can we reasonably expect that complex plan making discussions around spatial strategy and site options and allocations can be undertaken virtually with members and committees? Virtual meetings can work for decision taking, but the plan making arena is quite different. Concern is plans might seriously stall, more so than expected. I don't know who wants to go first on that one.
Well, I've said my take on that is that, in a sense, with the government stressing the 2023 deadline, and virtual meetings are authorised, as we know through the regulations that were made 2 or 3 weeks ago, a local authority ought to be able to grapple with these issues. And if it means that the members are going to need some assistance and training to help them to participate, then clearly officers have got to be able to provide that support. But there is an expectation on everybody to have to adapt. It will be a new way of decision making. But I think those of us who've participated in Zoom or Microsoft Teams meetings, we've all found them, no doubt a little bit awkward, but they are perfectly capable of allowing things to be aired, things to be discussed, other parties' views to be heard. And so I think the dialogue that you might see in a typical committee meeting is perfectly possible to be achieved. So I would hope that local authorities do step up to the plate. And I think the deadline from the government may very well encourage them to do so. Right, we are slightly over time, so I don't know if there's anything else that you picked up in the questions that looks particularly burning. We'll deal with it. Otherwise, I think we may draw things to a close.
No, I think those were the main ones that haven't already been addressed in the talks that we've given.
Great. Well, thanks very much. Thank you very much to both Wayne and Rob for their presentations, and thank you to all of the delegates who've attended and participated. It's been hopefully of some use and useful to us to be able to air our thoughts on these matters. Your questions were certainly stimulating, and as I think has been indicated, the presentation will be on the website. I think there's a recording of this which may become available, so stay safe, stay well, and keep working. Thank you very much.